Good evening, everyone. On behalf of Livelaw Academy, I welcome everybody to the lecture on irretrievable breakdown of marriage. I'm Rohit Rohilla, and I'm one of the faculties and mentors uh, for you with respect to Livelaw's Judicial Services Examination Prep course. And before we begin with the topic, I would like to point out two very important things. First one is regarding the doubts. For doubts, you can type them in the chat box, comment box, and all the doubts can be taken at the very last, towards the end of the class. And the second important issue that I would like to highlight is I would be using the short form IRB for irretrievable breakdown of marriage because it is a kind of tongue twister for me. And I just wanted to put this before we begin. And having put these confessions and caveats before you, I think we can begin. So let me just share my screen. So what I have done before getting into the topic, I have listed down some subtopics from this particular area. These subtopics are more than enough and more than relevant for any judiciary aspirant to tackle any kind of question that comes from this particular area. So, firstly, I'll be discussing the present grounds of divorce that are available under the Hindu Marriage Act. Then we will move on to the basis of theory with respect to IRB as a separate ground of divorce. Moving further, I will also be discussing some examples from different legal systems where IRB has been accepted in one way or the other as an additional ground or as the sole ground of divorce. After discussing all this, then we will try to answer one fundamental question, that is, should HMA, that is Hindu Marriage Act of 1955, should be amended to include IRB as a separate ground of divorce or not, and whether there is a need to completely do away with the already existing grounds, or should we also keep them in addition to IRB. In the same direction, I will also be highlighting what the Law Commission has to say about IRB as a ground for divorce. Then we will be discussing how courts have been granting divorce on this particular ground, though there is a legislative gap clearly in the statute. What provisions are being evoked, are being involved, and how are they interpreted by the courts to grant divorce in appropriate cases. And finally, we'll end with some landmark cases, which will obviously bring more clarity to this particular concept. So coming on to the present grounds that are available under HMA. For this, refer to one can refer to section 13(1), 1A and subsection 2 of section 13 along with section 13B of the Hindu Marriage Act. They contain all the provisions highlighting all the grounds that are available for seeking dissolution of marriage under the broad term divorce. So, subsection 1 and subsection 1A of section 13, they list down certain grounds that are common grounds of divorce for both husband and wife, meaning thereby that either the husband or the wife can invoke these grounds to seek dissolution of marriage. Then subsection 2 of section 13, it deals only with the grounds available specifically to the wife. It lists down four additional grounds. It provides four additional grounds that can be made use of only by the wife and not by the husband. Then you have section 13B, which was inserted by way of amendment in the year 1976. This year is important because sometimes in prelims, examiners have this tendency to ask direct questions from from the years, the section numbers. So usually you will find um, the uh, the question based upon the amendment and the year of the amendment. So it was introduced by way of amendment in 1976, and it provides divorce by mutual consent subject to one condition, that the couples must have been living apart for 1 year at least. So the section says that the couple must be living apart for 1 or more year. So at least 1 year living apart is the condition that needs to be satisfied before seeking divorce on this particular ground under section 13B, that is by way of mutual consent. Addition to this, the section requires a joint petition by the couple. There has to be a joint petition asking for the this particular relief, and then there are certain other procedural requirements that are to be met. For example, there is a cooling off period that the parties have to make two motions, one and the mutual consent has to continuously be present throughout the proceedings at the time of first motion as well as at the time of the second motion. However, getting into the exact details of the grounds provided in section 13, be it subsection 1, 1A, and subsection 2, and the procedural and substantive aspects of section 13B, there is no need to go into great details of these grounds as of now, because our agenda for today's class is only to understand IRB and its implications. So, getting into the details of grounds in particular, then it requires a separate session and it will be a subject matter of a different class. So, having said that, but it is very important to understand these grounds in terms of theories. At least it will be very convenient for us if we group these grounds in certain categories of theories, because that way we will be able to appreciate the theory on irretrievable breakdown IRB in a much more better way. So, having said that, we can categorize these grounds in terms of three different theories. The first one being traditional theory of matrimonial fault, the second is theory of frustration, and lastly, there is a theory of consent. None of these grounds they deal with breakdown theory in any manner whatever. So coming to the theories, we'll take each theory one by one. Starting from the first one, as I have said, that one of the fundamental theories relating to divorce is theory of matrimonial fault. Now, this particular theory contemplates those circumstances where one of the parties is at fault and the other party is the sufferer. There is some sort of wrongdoing that is being done against one of the parties to the marriage by the other. It can it the glimpses of this particular theory are very well recognized under section number 13, when we talk about grounds like adultery, when we talk about cruelty, desertion, and as I have said, subsection 2 provides certain additional grounds to wife only, when wife can petition on the grounds of bigamy, sexual offenses, and failure to pay maintenance. They are all glimpses of some kind of fault or disability against one of the parties. Then we have theory of frustration. Now, this theory of frustration deals with those situations where neither party is at fault. In the terms we have just understood, that there is no wrongdoing being committed by one of the parties to marriage against the other. Simply, the objective of marriage is it seems to have been frustrated because of happening of some kind of supervening circumstance, rendering the requirement of putting an end to the marriage a necessity because of happening of those supervening circumstances. Basically, the supervening circumstances that were not contemplated by the parties initially. but due to the happening of those circumstances, some new material changes have occurred in the matrimonial relationship of the parties. The examples of this can be conversion of the other spouse to some other religion. This is a material change. Then a party suffering from insanity, disease, when one party renounces the world, because as we know that one of the objectives of marriage is to procreate, and it also has some religious objectives to fulfill. It is a kind of, people view it as a kind of obligation that we need to fulfill towards our ancestors by continuing the family lineage, so that various social and religious ceremonies can be carried out. So, if one of the spouses it renounces the world, that frustrates the very objective of the marriage, right? So, in that case, also it is a frustration of the matrimonial relationship. Then, absence of the spouse for a very long period. Now, apart from having religious significance, marriage also carries some social and individualistic objectives. So, if a particular spouse is absent for a very long period of time, that then it will surely result in frustration of marriage in terms of the other partner. So that's how theory of frustration goes about, and all these grounds, you can find all these grounds in section number 13. Section number 13 also talks about conversion of one spouse to other religion. It also talks about insanity. It also talks about certain diseases, renunciation of world. Right, all these grounds are covered under section 13. So far we have discussed, we have seen that matrimonial fault as well as theory of frustration, both these theories, they find their manifestations in the provisions of HMA. Then moving forward, we have last theory, before we venture into IRB, the theory of irretrievable breakdown of marriage. We have theory of consent. Now, this theory of consent, it is based upon a theoretical assumption that since marriage is created, the institution of marriage is created through mutual consent, the same should be allowed to come to an end through the same mutual consent. So, if a party can consent to enter into a marriage, the party should also be allowed to move away from the marriage. So, this under this particular theory, there is no requirement as such to there is no necessity as such to show that the other party is at fault, or there have occurred some supervening circumstances which has rendered or frustrated the objectives of the marriage. There is no such requirement under this particular theory. It simply contemplates that if you are allowed to enter, you must also be allowed to take an exit from the marriage. Now, Section 13B, as I have also highlighted previously, Section 13B of HMA, it talks about divorce by mutual consent, but it is not purely based upon this theory of consent. It is slightly modified version of this theory of consent, because as we have seen that we require at least 1 year of separation between the parties, right? And so it is not purely a theory of consent. It is a modified version of theory of consent, right? Now, before we actually venture into theory of IRB, there is a need to address another critical and very important point, that is section number 13(1)(a). You will find uh, people often saying that glimpses of irretrievable breakdown of marriage, the theory of IRB, they are found in section 13(1)(a). But we need to examine whether it is actually true or not. So, well, yes, people definitely say, you will come across people saying that 13(1)(a it is a glimpse or it is a manifestation of IRB. But let me see whether I can change your opinion or not on this particular issue. So let me just show you section 13(1)(a). Section 13, it lays down grounds for divorce, as I have already told you. One, it is a common, subsection 1, it is a common provision applicable in case of both males and females. Then you have 1A, under section 1A, 13, subsection 1A, section 13, subsection 1A, uh, either party to the marriage can seek divorce. It is also one of the common provisions, right? It is only subsection 2 that is available only in case of wives. So, coming back to subsection 1A, both the parties can seek divorce under this particular subsection, but this subsection contemplates certain proceedings that might have happened between the parties already in the past. Right? Let's see how. It says either party to a marriage, which means either the husband or the wife can utilize this particular subsection, whether solemnized before or after the commencement of this act. So it has both prospective and retrospective operation. May also present a petition for the dissolution of marriage. Dissolution of marriage, how? By a decree of divorce on the ground. Then it lays down two specific grounds. Let's examine them one by one. The first ground states that there has been no resumption of cohabitation as between the parties to the marriage for a period of 1 year or upwards after the passing of a decree for judicial separation. Right? That's the first ground. The first scenario is where there has been a decree of judicial separation passed. One party has taken a decree, has obtained a decree of judicial separation from the court already, and upon passing of such decree there has been no resumption of cohabitation between the parties. Then only either party to the marriage becomes eligible to apply under section 13 subsection 1A. So as I have said earlier, as I have pointed this out for you, that 13(1)(8), and it contemplates uh, some preceding some preceding decree to base your claim under section 13 subsection 1A. Now interesting fact is this decree of judicial separation cannot be passed until and unless the party is at some fault or disability. Let me show you how. For judicial separation, we need to refer to section number 10. See, section 10 does not lay down other grounds for obtaining judicial separation. It takes you again to section number 13. The grounds provided under section 13 for divorce, they are as it is applicable in case of judicial separation. Let's see. So subsection 1 says either party to a marriage, again whether solemnized before or after the commencement of this act, may present a petition praying for a decree for judicial separation on any of the grounds specified in subsection 1 of section number 13, and in the case of wife also on the grounds specified in subsection 2. So it takes you again to the grounds mentioned in section 13, be it the case of subsection 1 or subsection 2. Now section 13, as we have already discussed, the grounds mentioned in section 13, they are glimpses of fault theory. They prescribe some faults or disabilities on the part of the parties to marriage, and giving an entitlement to the other party to obtain divorce, right? So for judicial separation the grounds are exactly the same. So when we say in subsection 13(1)(a) that after the passing of decree of for judicial separation there has been no resumption of cohabitation between the parties, we are actually basing the claim again on the fault of the parties. So, in this way, we cannot say that 13(1)(a), in case of judicial separation, where it contemplates that there was a previous decree for judicial separation, right? It is a glimpse of, or it is a manifestation of IRB, irretrievable breakdown of marriage. Ye completely, it is a flawed thing to say, right? Then let's examine second ground also. As per second ground provided in subsection 1A, you will find that this also bases the provision on a previous decree with respect to restitution of conjugal rights. Let's see that there has been no restitution of conjugal rights as between the parties to the marriage for again a period of 1 year or upwards after the passing of a decree for restitution of conjugal rights in a proceeding to which they were parties. So this also contemplates a previous proceeding between the parties in which a decree for restitution of conjugal rights was already passed, and there was no resumption of conjugal rights despite there having been passed a decree with respect to the same. Now, for RCR, we need to refer to section number 9. Section 9, restitution of conjugal rights. The conjugal rights, simply put, they are the rights that each party to the marriage they are entitled to in terms of the comfort and the company, the support that they seek from their partner, right? So when either the husband or the wife, I'm reading section 9, when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights, right? So, Section 9, which gives you the right to obtain a decree for restitution of conjugal rights, it states these words used by Section 9 without reasonable excuse and the phrase withdrawn from the society of the other. These things clearly indicate a fault of one party, is it not? Right? So again, section 13(1)(a) in its second ground also basing the right to seek divorce on an already passed decree which could not have been passed in absence of a fault from the other party. So in case of restitution of conjugal rights also, under subsection 1A of section 13, we cannot say that it is not based on fault of the parties. We cannot say that it is a manifestation of IRB, right? So this important point I wanted to highlight. So what we have learned from this discussion, that traces of the concept of breakdown of marriage, though people say, you will find some people saying that 13(1)(a) it carries some traces, it has some traces of the concept of breakdown of marriage. But as we have seen, that proceedings for divorce under subsection 13(1)(a) must have been preceded by either a decree of judicial separation or decree of restitution of conjugal rights. Now, upon reading section 10 and 9 for this purpose, we have found that 13(1)(a) indirectly brings in consideration fault or disability, right? So to say that they are based on IRB, I don't think it will be a correct proposition. Now, let's come to the theory of irretrievable breakdown, the theory of IRB. So this theory it postulates that restricting the grounds of divorce only in terms of faults, disabilities, or frustrations, it can cause injustice in some situations, particularly in those situations where parties are not at fault. There is nobody to be blamed, but simply the parties are not able to work out the relationship between them. There is no possibility of working out the marriage, but nobody can be blamed. No, there is no situation that one party should be can be placed in a position where a blame can be put, or there is a case of disability or frustration. None of these things are happening. Still, the parties are unable to stay with each other peacefully. So, in these situations, marriage has all the external appearances, but none in reality. For such kind of marriages, a court is often used I have also used it here that marriage is merely a shell out of which the substance is completely gone, which means that there is no lively relationship between the parties to the marriage. They are not emotionally connected. They are not ready to support each other. They have developed feeling of animosity towards each other. There is no affection left. So in such kinds of situations, they just simply want to put an end to their misery and get out of the marriage. But none of the provisions of Section 13 are applicable. Right? So definitely in such situations, the divorce law, as in its present form, will surely result in injustice. And when there are only thorns and no roses in a marriage, जब सिर्फ कांटे ही कांटे हों और गुलाब कोई भी ना हो. Now, gulab, the rose is a symbol of, it symbolizes love and affection. So when there are no thorns and when there are only thorns and no roses in the marriage, then there is no point in keeping it alive. The parties should be given an option to put an end to such a miserable marital life. So irretrievable breakdown of marriage, this theory, it sees divorce as a kind of solution in such situations. It sees divorce as an escape route for the parties where they can put an end to their miserable lives. And as such, IRB is not at all concerned with the wrongs of the past, as in the case of fault theory or the frustration theory, right? They are not at all concerned with the wrongs of the past. The only concern of IRB, the theory of IRB, is to bring the parties and children to terms with the situation that is facing them, right? So the eyes are on the future rather than being regulated by the past wrongdoings. So IRB, it says that in order to make the future lives better of the parties involved, of the children involved, um, it is advisable that in such frustrating situations where there is no ground applicable to the parties, where there is no ground of divorce that can regulate a particular case, a particular situation, then in those cases also, when there is nothing left in the marriage, there is no substance, the shell is completely empty, there is no love, no affection, only thorns, no roses, right? Then the parties must be allowed to seek dissolution of marriage, even in such grounds, even in such situations, right? Now let's move on to some comparative perspectives. So, UK and US, they are the classic examples of the countries that we take when we do any kind of comparative analysis. UK in particular, because we have same kind of legal system, because for obvious reasons we were ruled by them, and we have continued the with the same system. And in UK, they have introduced the concept of non-fault divorce in the year 2020, wherein they require the parties that if they are living separately for a certain specific period of time, they can seek divorce. They can seek dissolution of their marriage, even in case of no fault of the parties. Then we have Australia, and this part is interesting. In Australia, IRB is the sole ground for seeking divorce. Now, this is very interesting. They have done away with all the other kinds of grounds and have kept only IRB. It is the sole ground for seeking divorce. The law of Australia, it requires that in order to seek dissolution on this particular ground, the parties, the couples must have lived separately for more than 12 months, that is, for more than 1 year. एक ईयर से ज्यादा आपको सेपरेटली रहना पड़ेगा टू बी एलिजिबल टू अप्लाई फॉर डिवोर्स on this particular ground. Then US also allows IRB ground to be taken in divorce proceedings along with other grounds. Along with other grounds. Now, the fundamental question that comes for our consideration is um, is should HMA, that is Hindu Marriage Act, be amended to include IRB as a separate ground for divorce? Now, to answer this question, I need you to think very with an open mind, to think with an open mind, to think with an open mind, and just observe the kind of development we have had in terms of family and in terms of our social lives. Our family relationships, they have become more and more democratic and more egalitarian, in the sense that now people have they enjoy same or equal status, equal opportunities, equal duties, and privileges. So now we see that husband and wives, they do not only share the matrimonial house, but in some cases they share their earnings as well, right? So this fundamental change in the family structure, wherein we have seen an increase in the rate of female activity. So this rising rate of female activity has completely transformed the family structures. Now the families, they are more of a coalition, working together and supporting each other rather than being dependent on one particular party, right? It has become more of a coalition. So, just like we have in politics, where coalition governments, they are not able to survive because they compete, the parties holding each other together, they cannot work out um, their differences. The same things apply in case of families as well, right? Where this coalition simply does not, it is not able to work out. It is advisable to put an end to it, right? So, considering all these changes, considering all these social aspects, and these recent developments of recent times, we should not be hesitant in recognizing IRB as a separate ground for divorce, and definitely we need an amendment in Hindu Marriage Act. Further, when we view it from a different lens, we will reach to the same conclusion. If we consider the fault theory is completely inadequate to deal with the situations which are contemplated by theory of IRB, and uh, we under this kind of system where blame is to be put on one of the parties to the marriage, it definitely brings the institution of marriage into disrepute. It brings many bad things which otherwise would not have been there with respect to the institution of marriage. The advocates are constantly looking for um, are looking for these faults of the parties that are being contemplated in section 13, and then they try to expose the other party, and wherever the parties cannot end their or part their ways peacefully without being labeled as innocent or guilty party. So such kind of system, definitely it needs to be changed. We need to have a relook, and the kind of system that we have, it leads to allegations that are freely hurled across the courtrooms, right? So judges are also reduced to to such parties in such cases that they are exposed to such obscenities and such negative things about marriage, which otherwise would not have been highlighted in normal circumstances. So definitely, if we recognize IRB and amend HMA, it will help us in restoring the respect that the institution of marriage once enjoyed, right? So for from that perspective also, HMA needs to be amended. Now in that direction, it would be very beneficial for us if we look at the opinion of the Law Commission of India on this particular issue. So the Law Commission of India, under the chairmanship of Justice HR Khanna, you must remember or must be able to recall his name. Justice H.R. Khanna is one of the famous legal personalities that this country has seen. Not only for his stand in the ADM Jabalpur case, but his significant role in Keshavan Bharti case, where the balance would have been tilted to the opposite side if H.R. Khanna uh, would not have been there in the middle of the two groups of judges. So under his chairmanship, Law Commission of India gave its 71st report, and in this report also they have acknowledged that breakdown of marriage should be recognized as a separate ground for divorce. But the Law Commission has clarified two things, that it should be based, the ground should be based on it should be based subject to one condition only, that parties must have lived apart for a specified period. Now, this requirement we have seen that it is prevalent in other legal systems as well, including Australia and England, right? And the law commission has further clarified that living apart for the specified period should be the only proof of breakdown of marriage, which means no fault, no cleaning of dirty linen in public is required to be done if you want to seek a divorce on this particular ground. Only prove that you have been living apart for a specified period of time. And what is that specified period of time? The Law Commission has prescribed that it should be 3 years. Now, the reason behind prescribing the time period of 3 years is twofold. Firstly, it is not short enough so that the parties are not at all able to reflect on their decisions, and the time period should not be such that it is inconsistent with the stability of the marriage, right? So it is long enough for the parties to reflect upon and take an informed decision, and it is not long enough that it results in further bitterness between the parties, right? So it is not long enough in the sense that it prolongs the agony of the parties to the marriage. So that is the rationale behind prescribing 3 years by the Law Commission. Now, interestingly, though Law Commission has favored IRB to be recognized as a separate ground for divorce, they have also favored the retention of the existing grounds, and rightly so, because certain practical considerations cannot be brushed aside when we take into consideration IRB. Take for example the grounds of divorce like cruelty, adultery. If we completely do away with these kinds of grounds, then and prescribe a specified time period for IRB, right? So then the parties will not have any option but to wait for 3 years. So such a result is completely undesirable. So that what Law Commission has suggested, that though there is a need to have IRB, we should also retain the already existing grounds of divorce for practical considerations, right? Now, clearly, there is a there is a legislative gap with respect to IRB, and the Law Commission has also suggested, but no amendments have been carried out as on today, right? आज तक भी the 71st report of the Law Commission, it has not been implemented with its full force. IRB is not being has not yet been recognized as a ground for divorce, though they have suggested that new provisions 13C, D, etc. they should be added with along with the time period specified and along with certain safeguards, but no amendments of such nature have been carried out. But you must have seen that courts have been granting the divorce on irretrievable breakdown of marriage. Um, how are they able to do it? So for this, we need to understand one of the important provisions from our constitution, that is Article 142. Article 142, it is an exclusive provision meant for the Supreme Court, which gives it very wide discretion to exercise their power, to exercise the power to ensure that justice survives, to ensure that there is complete justice in any case that is before the Honorable Supreme Court. So the Supreme Court has been utilizing this Article 142 to bridge the legislative gaps and take actions that otherwise may not be available within the strict confines of statutory law. And you might have come across some directions that are being passed in to counter certain situations pertaining to environment, to deal with some problems relating to human rights, to ensure institutional accountability, right? All that kind of directions, they come under Article 142. Supreme Court issues them, until the time legislature takes a call on such issues. Those directions that are passed by the Supreme Court under Article 142, they work as a complete law in themselves, right? So that is the kind of power Article 142 grants to Supreme Court. But uh, we must also realize that since it has very wide connotations, and with absolute powers, the responsibilities also come. So the Supreme Court confines itself, or self-regulates itself. We can say that it does not um, exercise this jurisdiction very lightly. But in appropriate cases, the Article 142 can be pressed into action in order to do complete justice. And through Article 142, the Supreme Court has been creatively interpreting laws to fill the gaps that are created by laws. Right? I've given you the examples from environment, from human rights, and also from the point of view of ensuring accountability of the institutions. So here, the intention behind Article 142 is not to replace the legislative function. We must be clear about this, right? Because ours is a constitution which is based upon separation of power. So the idea is not to replace the legislative functions or to trump the legislature. It is just to ensure that justice is not delayed due to gaps in the law. So if there is a gap in a law, and legislature has not given it a serious thought, or they also have many things to cater to. So, in their priority list, the issue comes at a later stage, right? So, in such situations, the justice should not be, it should not sit idle and wait for the legislature to act. In such situations where promptness is required, 142 is a kind of weapon, in an additional weapon in the arsenal of the Supreme Court, which can be utilized for such situations, to deal with such situations. So it has definitely become a powerful tool for the Supreme Court, allowing it to act as a guardian of justice, right? So in such cases where the marriage has completely broken down, where there is no affection between the parties, where there are no chances of reconciliation between the parties, yet nobody can be blamed for anything, right? So, in order to do complete justice between the parties, the Supreme Court can utilize Article 142, and have been utilizing Article 142 to grant divorce in such cases, right? So, 142 is the only provision for seeking a divorce under this particular ground, on this particular ground, right? The civil courts are not empowered to grant a divorce on this ground. The high courts are not empowered. It is only and only the Supreme Court under Article 142 that can grant a divorce on the ground that marriage has completely broken down, on the ground that there is irretrievable breakdown of marriage, right? Please keep this thing in mind. Now, with this, we move on to the landmark cases. So I have listed three cases here. Two of them are from the earlier years, when the issue of IRB was very hot. And now we have a case. Lastly, I have a case listed here from the year to 2023, which is a sort of repetition of the principles already mentioned in the previous cases. But there is one additional, one very important observation made in 2023 case. We'll see what is that about. Right? Now, coming to the first case, Ashok versus Rupa. This is a case from 1997. So here the couple married in December 1970 and they started living separately since 1983. And in the year 1984, they filed a joint petition for divorce under Section 13B. Right? Section 13B, we have already discussed that it deals with divorce on mutual consent. But in the year 1986, before the decree could be passed, the wife, Rupa, withdrew her consent, citing some dissatisfaction with the kind of settlement she was receiving or kind of treatment the husband was giving her. Um, um, so what has happened? She has withdrawn her consent, and without her consent, without mutual consent, the court cannot grant a divorce under Section 13B, right? And there were other multiple litigations pending between these two, and uh, in fact, they were living separately since 1983. In fact, the husband he got married for the second time, despite the fact that proceedings were pending between them, right? So for that the husband received the backlash from the court, definitely. But the court in this particular case, looking at the scenario, looking at the facts, that they first applied for divorce by mutual consent. Then after good 2 years, she withdrew her consent, and since 1983 they have been living separately. There are no chances of reconciliation. The parties have continued to live separately, and even the husband has got married second time, uh, d- during the pendency of the multiple litigations between the parties. The court invoked Article 142 to do complete justice in this case, and the court has also referred to the Law Commission's recommendation that we just discussed in 71st report, right? They have referred to those recommendations, and they have observed that where marriage has ceased to exist in substance and in reality, there is no reason for denying divorce when the relationship is beyond repair. So the court, in a way, has passed. It has made a sort of bypass around the procedural technicalities of Section 13B, which requires mutual consent to be continuously there till the decree has been passed, right? Uh, in spite Despite of the fact that one of the parties has withdrawn the consent and there can be no decree under 13B, the court can grant, as per this decision, can grant divorce in such situations where the marriage has ceased to exist in reality, where there are no chances of the relationship between the parties getting repaired, right? So the court has utilized 142 and granted divorce. Similar to this, we have a case of Anil Kumar Jain versus Maya Jain. It is a case from 2010, again by the Supreme Court, right? So the couple in this particular case, sorry, sorry, in this particular case, they got married in 1985. Again, there was a joint petition in this case as well under 13B, right, in September 2004. Now, what happened in this case? After 6 months, the wife withdrew her consent. Now, why this withdrawal happened? Actually, there was a settlement between the parties. The husband and wife, they mutually decided that there are certain things that need to be settled in terms of maintenance and in terms of property. If they are settled, the divorce can happen through mutual consent. And the proceedings that have been that were initiated in 2004, they can continue with mutual consent of the parties. So there was a settlement, but after getting the properties under the settlement, the wife withdrew her consent, right? And not only withdrew her consent, the wife, even after withdrawal of consent, the wife even refused to go back to the matrimonial house and continue the matrimonial life, right? So it is a classic example where the party was blowing hot and cold at the same time. And it is one of the principles of law that you cannot reprobate and reprobate at the same time. You have to take one position. So on one hand, she was not ready to continue with the divorce proceedings by way of mutual consent. And on the other hand, upon withdrawing the consent, she was not ready to continue the matrimonial obligations as well. Right. So, court took note of all these facts, and after referring to two judgments. One is Sureshta Devi versus Om Prakash. This is judgment on 13B, not on IRB, right? It simply states that the mutual consent must continue till the decree is granted. So, court noted this judgment. But at the same time, they also refer to Ashok versus Rupa's case that we have just discussed, right? They referred to this particular case and said that 142 can be utilized where there is irretrievable breakdown of marriage despite the withdrawal of consent from one of the parties, right? The court also observed that the wife's refusal to live with the husband while rejecting mutual divorce, right, it is completely against the spirit of 13b. And also, the court held that the wife's decision to withdraw consent post property transferred, it is demonstrating what? A clear breakdown in the marriage. That she took the property in terms of the settlement and then withdrew the consent. Right? It clearly shows that there is a complete breakdown between the marriage, in the marriage between the parties. Right? The wife simply wants to put the husband through a lot of suffering and pain. That's it. Rightly, the Supreme Court has utilized 142 and granted divorce in this particular case on the ground that it was broken down completely. Now we have a case from 2023, Shilpa Sailesh versus Varun Srinivasan. Some of the observations made by the court in this case, you will find them repetitive, whatever we have discussed so far. But one very important, as I have said before, also that there is one important observation made by by the Supreme Court in this case. So let's go point wise. In this case, the Shilpa and Varun, they were having multiple litigations pending between them, and both of them sought divorce. They want to put the misery to an end, but due to some procedural and legal complexities, the resolution was simply not possible. So the Supreme Court is approached to exercise its powers under Article 142 to dissolve the marriage, again citing irreparable breakdown of or irretrievable breakdown of their relationship. Right? The court invoked 142. They acknowledged their powers under 142, and yes, they said that the divorce can be granted, but but this part is very important, as I have told you, that no court other than the Supreme Court can entertain the petitions on the ground of IRB, right? It is only the Supreme Court that can pass a judgment under Article 140, that can make an order under Article 142 to bring an end to the matrimonial relationship on the grounds of IRB. Here also in this 2023 judgment, the Supreme Court clarified that parties cannot directly approach the court under Articles 32 or 226 even. Now 32 and 226, they are also extraordinary jurisdictions for Supreme Court and High Courts respectively. The parties cannot approach under 32 or 226. Even under these provisions, if you want a divorce on this particular ground, only 142 can be invoked, right? This must have been done, though there was no clear cut reasoning in the judgment when you go through it as to why it is observed, but one can make out the reason could be that 30 allowing such petitions to be made under 32 and 226, right, it will open the uh, it will open additional options for the parties, and it is advisable to bring more certainty into this aspect till the legislature takes a call. Let them come to the Supreme Court and be dealt under 142, right? It is for the sake of certainty in law that this must have been done, right? Though no clear reasons were provided in the judgment. So that's all from my side. As far as irretrievable breakdown of marriage as a concept under Hindu law is concerned, now I will be happy to take your doubts. And before we take your doubts, let me just clarify another important aspect from examination point of view. From examination point of view, you can expect a question based on the philosophy of IRB, wherein the examiner can ask you to examine the postulates of the theory of IRB and whether you are for it or against it, whether there are some merits in that theory or not. You can also expect a problem based question, particularly in states like Haryana and Delhi, wherein the examiner, when he or she becomes more adventurous in the sense that they formulate a problem which are not covered by any of the grounds specified in HMA, but still you think that something needs to be done, right? The marriage should be put to an end, but the court is not specified, right? So there you should discuss the law, but you should also point out that the powers can only be exercised under Article 142 and not by the district judiciary, and not even by the high courts, right? So these two types of questions can be asked. Then there can be a short note, which will not require to go into the details, right? But you must clearly highlight each and every aspect as far as possible, right? And that's all. Now I will be more than happy to take your doubts. Okay, okay, okay. So Anirudh says, no doubt, sir. Oh, everything is clear. Thank you very much. Thank you, Anirudh. Thank you. If you have found this lecture valuable, it is my pleasure. And we intend to continue this thing, that things will be uh, as clear as possible to you so that you can approach these exams with confidence. And uh, I think on that note, if we have no other doubt, yes, yes, no other doubt. There's no doubt in the chat box or the comment box. I believe we can end this session. But before parting ways, let me just say that continue to work hard. We'll be coming up with more such sessions for you. Do attend them, and hopefully, we will continue this journey together. We'll continue this journey together, and in the classes, particularly, we'll go uh, topic wise mostly, and the way we have done in this particular class, though it depends on the kind of topic that we will be discussing in one particular class. We can either go topic wise or bare act wise, but going bare act wise is not advisable at all. It is a sort of, it becomes a sort of cramming rather than understanding the law. So our objective is to give you the complete understanding of the law. So most probably we'll be going topic wise in the classes. And till next session, till next session, I urge you to work hard, take good care of yourself, and I'll see you in the next one. Thank you very much.